You've probably heard that phrase during a traffic stop. The officer leans in, tone deceptively casual, and asks, "You don't mind if I take a quick look, do you?" It sounds like a simple question, a minor courtesy. But beneath that polite veneer lies one of the most powerful and misunderstood tools in law enforcement, the consent search. Here's the terrifying reality most people never learn until it's too late. Your answer, whether it's yes, no, or a confused mumble, can be legally manipulated to remove you from your vehicle, authorize a complete dismantling of your car's interior, place you in handcuffs, and lead to your arrest. The most shocking part? The U.S. Supreme Court has repeatedly upheld that officers are under no obligation to inform you that you have the absolute right to refuse. They can legally let you believe you have no choice. I'm Jeff Hampton, the people's lawyer. In this breakdown, I'm going to dissect for you. First, the meticulously crafted verbal and psychological traps, straight from police training manuals, that officers deploy to gain legal access to your vehicle. Second, the precise, actionable strategies to identify and neutralize each trap, preserving your constitutional protections in real time. And stick with me to the very end, because I will provide you with a definitive, word-for-word legal script. You can screenshot it, memorize it, and use it to create an immovable legal barrier between an officer's request and your Fourth Amendment rights. Trap number 1, the linguistically engineered double-bind question. The scenario: your heart is pounding against your ribs. The police cruiser's lights paint the interior of your car in flashes of red and blue. The officer approaches, not with aggression, but with a calm, almost friendly demeanor. He leans down to your window and asks, "Don't mind if I look around, do you?" The analysis. This is not a simple question. It is a linguistic trap engineered to induce cognitive overload under stress. Grammatically, it's a confusing double negative. Psychologically, it's a compliance-gaining technique. If you say yes, you could logically mean yes, I don't mind. But in the officer's report, that will be transcribed as unambiguous consent. Driver stated yes to a search. If you say no, you likely mean no, I do not want you to search. The officer can later testify. I asked if he minded, he said no. I interpreted that as him not minding, so I proceeded. The win-win. For them, the question's very structure is designed to make you stumble, creating ambiguity they can later interpret to their advantage. The Supreme Court has set a very low bar for what constitutes voluntary consent, and a mumbled "I guess" or nervous nod often clears it. The enhanced detail. This tactic preys on our ingrained social desire to be polite and non-confrontational, especially with authority. In the high-stress, asymmetric power dynamic of a traffic stop, your prefrontal cortex, the part of your brain responsible for complex decision-making, is literally impaired. They are counting on you to default to politeness, not constitutional calculus. Your tactical defense. Never engage with the confusing question. Do not try to explain, justify, or parse the grammar. You must respond with a clear, unequivocal, and legally potent statement that removes all ambiguity. Officer, I do not consent to any searches. Repeat it verbatim if questioned further. This phrase is a shield. If you can, ensure your phone is recording or note that their body-worn camera is active. You are creating a definitive record. At no point did you grant permission. Trap number 2, the innocent until proven guilty reversal, the two-step setup. The scenario: the officer, after taking your license, returns and adopts a more conversational tone. Step 1, he asks, "So, is there anything illegal in this vehicle today? Any drugs, weapons, anything I should know about?" The psychology. This is the hook. It feels like a standard question. Your instinct, because you're an honest person with nothing to hide, is to quickly clear the air. "No, sir. Nothing like that at all. You just taken a bait." Step 2. The officer nods, then smoothly transitions. "Well, if there's nothing illegal, then you won't mind if I take a quick look, right?" The analysis. This is a masterful psychological play. It reframes your constitutional right to privacy as evidence of guilt. Suddenly, asserting your Fourth Amendment right feels like admitting you lied in step 1. The officer has artificially created a false dichotomy. Either you're innocent and comply, or you're lying and have something to hide. This pressure is immense and by design. The legal truth emphasized the Fifth Amendment protects you from being compelled to be a witness against yourself. You're never legally required to prove your innocence by surrendering your privacy. The Fourth Amendment exists precisely to protect the innocent from arbitrary intrusions. Feeling guilty for asserting a right is what the trap is meant to produce. Your tactical defense. You have two primary countermaneuvers. The full invocation strategy, most protective when asked step 1, respond. Officer, I respectfully invoke my Fifth Amendment right to remain silent and my Sixth Amendment right to an attorney. I will not answer any questions without my counsel present. This stops the two-step process dead. It may feel extreme, but it is the most constitutionally sound position. The post-answer clarification. If you've already taken the bait, if you already said no, and they move to step 2, you must firmly decouple the issues. Officer, as I stated, there is nothing illegal in my vehicle. However, I do not consent to a search. This statement holds two truths simultaneously: your innocence and your insistence on your rights. It is perfectly legal and logical. Trap number 3, the de-minimized deception, the quick peek lie. The scenario, the officer makes it sound trivial. Mind if I just take a quick peek? It'll take 10 seconds. I'll just glance inside and you'll be on your way. The mental image. They want you to picture them leaning in, taking a brief, cursory look at your front seats, and then waving you off. This feels like a small concession to expedite the stop. The harsh reality. In legal and practical terms, a consent to search has no time or intensity limits. Your quick peek is their legal blank check. I have represented clients whose quick look turned into a 90-minute forensic excavation. Seats slashed open, door panels pried apart, personal luggage emptied onto the asphalt, and air vents disassembled. Even if you are utterly innocent, you could be left stranded on the roadside with a destroyed vehicle. The legal fine print. Once you consent, courts grant officers broad latitude to search any area of the vehicle where the item they claim to be looking for could reasonably be concealed. Could I see your trunk? Can become them dismantling your spare tire well. A glance at the passenger seat authorizes them to probe under all seats and inside any container large enough to hold contraband. Your tactical defense. Recognize the phrase quick look for what it is, a euphemism designed to lower your defenses. Your response must reject the premise entirely. Officer, I do not consent to any search of my vehicle, including a quick look or a peek. If they retort, why not? If you have nothing to hide, do not be drawn into their logic trap. Simply repeat, I'm not discussing the matter. I do not consent to a search. Your justification is the Constitution. You need no other. Trap number 4, the fabricated time crisis, the warrant threat bluff. The scenario, you've held firm. The officer's demeanor shifts. The friendly pretense drops, replaced by imposing authority. Look, if you don't consent, I'm just going to call a judge, get a telephonic warrant, and you're going to sit here in cuff for the next 3 hours while we wait. Make it easy on yourself. The psychology, this is pure coercion. It weaponizes your desire to get home, to avoid a public spectacle, and to end the stressful encounter. It's designed to make the path of least resistance, consent, seem rational. The reality check. To legally obtain a warrant, even a telephonic one, the officer must have probable cause, a specific, articulable fact-based belief that evidence of a crime is in your car. Not a hunch, not nervousness. Draft an affidavit. Write a sworn statement detailing that probable cause. Find a judge, reach a magistrate, present the affidavit, and persuade them to sign. This is not a quick process. Crucially, if they had the probable cause to secure a warrant easily, they would not need your consent. The threat is often a bluff to bypass the warrant requirement altogether. Your tactical defense. Remain calm. Your response should be polite, firm, and expose the bluff without confrontation. Officer, as I've stated, I do not consent to any search. If you believe you have sufficient probable cause to obtain a warrant, I will wait here patiently while you initiate that process. Critical protocol if they search anyway. Do not physically resist. Physical resistance is a crime. Your battlefield is the courtroom. Instead, state loudly and clearly for every recording device. Officer, I am expressly stating that I do not consent to this search. I am protesting this as a violation of my Fourth Amendment rights. This formal objection is vital for your attorney to later file a motion to suppress any evidence found, or to pursue a civil rights lawsuit for an unlawful search. Trap number 5, the assumptive command, the fake order. The scenario. This is the most aggressive trap. The officer does not ask. He commands, step out of the vehicle. I'm going to search the car now. Pop the trunk. It is delivered as a foregone conclusion. The psychology. This tactic leverages sheer authority to bypass your conscious decision-making. It triggers a deep-seated instinct to obey direct orders from figures of authority. Many people comply simply because the phrasing, I'm going to, makes refusal seem futile or even rebellious. The legal chicanery. Later, in reports and testimony, this interaction will be reframed. The driver complied with my request to open the trunk will become the narrative. Your silent compliance or mumbled, okay, under extreme pressure will be characterized as implied consent. Your tactical defense. You must verbally interrupt this assumptive script and force a clarification. Use their command against them. Officer, to be clear, are you ordering me to open the trunk based on probable cause, or are you asking for my permission? Because if you are asking, I do not consent to any search. This does several things. It breaks their momentum. It creates a clear legal record of your non-consent. It forces them to either justify the search as a lawful order, which requires a higher legal standard, or admit they're seeking permission, which you deny. If they insist it's an order, respond. I understand you are giving an order. For the record, I do not consent. Then comply with the order to avoid charges of obstruction while preserving your legal challenge. Your constitutional action plan. The word-for-word script. Memorize this. It is your operational manual for protecting your rights. For any ambiguous request to search. Officer, I do not consent to any searches. Am I being detained, or am I free to leave? For the anything illegal, 2-step. Preferred. I invoke my right to remain silent and my right to an attorney. I will not answer questions. Alternate. There is nothing illegal in the car. I do not consent to a search. For the quick look or peek. I do not consent to any search, period. For the warrant threat. I do not consent. If you have the probable cause for a warrant, I will wait while you secure one. For the fake order, I'm going to search now. Are you asking or ordering? I do not consent to a search. The ultimate takeaway. Police are trained professionals in the art of obtaining consent. Their tactics are refined, legal, and devastatingly effective because they exploit human psychology and social conditioning. Your nervous silence, your polite hesitation, your desire to appear helpful, all can be weaponized against you. But your words, when clear, calm, and constitutionally grounded, form an impenetrable barrier. You control your voice. Use it to invoke the rights that are your birthright. We've just mapped the minefield of consent searches. But the roadside playbook is far larger. In my next video, I dissect the escalating tactics officers use when you refuse consent, from illegal orders to exit your vehicle to fabricated claims of officer safety that suspend your rights entirely. This is critical knowledge you cannot afford to miss. Stay aware, stay firm, stay free. I'll see you in the next one.